fascinating. But my topic today is statutory wills. And you hear statutory, you think legislation, you think government, sounds really boring. But I actually find the area quite fascinating, and I hope that my talk today will be interesting to you as well. The reason that we're bringing the statutory will topic back up today is that there was a case that came out at the end of the last year that took a slightly different slant to quite a lot of the circumstances that we've seen previously. So what is a statutory will? Just as a general refresher, it's just a will that's been made or authorised by the court by a person who is still, for a person who's still alive but has lost testamentary capacity. And generally the applications come about because there's been some change in circumstance for the person that renders their old will somehow inappropriate. It'll end up with a really bad circumstance that we want to avoid. Or if they didn't have a will or they were a minor, the rules of intestacy are somehow inappropriate. You're not usually going to go down this sort of process unless there is that inappropriate outcome that's going to be had, because it is quite expensive, but it is a useful tool to keep in mind. So when the court is considering these sorts of applications, they go through the same sort of factors as we would go through with you when we're considering your estate planning. So we go through your assets. What are your assets? Who is your family? Who might have a claim against you? And what are your wishes? What do you actually want this will to look like? But the court has to go one step further. They have to ask, in relation to the will that's being proposed to them for them to authorise, is this or may this be a will that the person would make if they had testamentary capacity? Now, one of the easier cases to see how this can work is where your child's going through a divorce. So who here has at least contemplated having a testamentary trust in their will? Some people? Yeah? A lot of people, that's good. And one of the reasons that you might do that is to give your children or your heirs a level of protection if they're going through a divorce, and to protect the inheritance that you've passed down to them. So in this case, allowed the court to insert essentially testamentary trusts into this person's will when she didn't have capacity to do it herself, but her child was going through a divorce and there was a potential that he would receive his inheritance personally and it would get lost to the spouse in their property settlement. And the court was able to see that there was plenty of evidence around that she had always wanted him and his bloodline to receive this property and not the spouse. She'd received the property that she wanted to give him from her parents, so there was this consistency in the wishes that they could see that it was appropriate to put testamentary trusts in on her behalf. But what happens if you can't see those wishes really clearly? What can the court do in that situation? And that's where this next case that I want to talk about really came into play. So if you can imagine you have an elderly relative, an aunt or an uncle or whatever it is. They're quite sick, they need care, don't have any children of their own. You and your siblings get together and decide to help her out and help with her care. Start visiting her more and more often, become more involved in her life, and she starts to tell you, assuming it's the aunt, she starts to tell you, oh, I want you to take my estate, I want you to have the benefit of it, share it with your brother and sister. But meanwhile she's telling the brother and sister, no, I want you to take all of the estate. And this is the context that we found this case of VMH in. So this case involved Mrs. C.E.K. How do I get this thing to... There she is over there. So Mrs. C was about 91. She had an estate of about $2.4 million, so not insubstantial. And obviously she had no children, and she had no children, so no one was really taking care of her. She had an appointed carer, but she was quite ill, as we said before. Now she had been quite close to her parents up the top there, and had lived next to them during her lifetime. When her parents passed away, she actually received the bulk of the father's estate, and there was a falling out between her and the brother, this one here. So he didn't receive as much and she received more, so there was a dispute and they had a falling out. So she was estranged from her nieces and nephews for about 40 years. During that time, obviously she didn't have any children, so she had made a will that essentially gave her estate to a couple of friends, Mr. and Mrs. B, with some pecuniary gifts, monetary gifts, to her carer, Bobby. After about 40 years, she was going on a holiday up in Townsville, and that happened to be where our friends down the bottom, nieces and nephews, were living at the time. They got back into contact, and the relationship started to be re-established after that 40-year period, quite a long time. So they started to become more and more involved in her life, visiting her as much as they could, helping her out, trying to get her a home up in the Townsville area. It transpired ultimately that she didn't want Mr. B over there to be her power of attorney anymore, so the brother down here helped her to bring some QCAP proceedings to kick him off. And as part of those QCAP proceedings, we found out that Bobby, the carer, was stealing from her. So it's the change in circumstance initially that we can see it's not really appropriate anymore to have him under the will, is it? Because he's been stealing from her. So the brother down here then was asking her, you know, as part of these QCAP proceedings, have you done anything about your will? What do you want to do about that? So she ended up making two changes. The first one was to, before she found out about the thefts from the carer, and the first change involved taking out Mr. and Mrs. B and inserting the brother as the residuary beneficiary, and then his sister Lynn if he passed away within the 30 days. The second change came after we found out about the thieving from Bobby, and she took out the gifts to Bobby, but she also took out the gift to Lynn. Now, Lynn wasn't told about any of these changes, even though she and the brother had been the primary caregivers for quite a long time at that point. She wasn't told about any of the changes to the will. She discovered it herself when she was helping Mrs. C open her mail, and she discovered the letter from the solicitor saying, here's a copy of your will, and here's all the things that it's got in it, and lo and behold, nothing to Lynn. She was understandably quite upset. So the application was brought by the brother because he wanted to make sure that the will, where everything was going to him, was the one that was going to be admitted into probate, and there was some question around whether those changes that she made around the QCAT, the time of the QCAT order, whether she had capacity to make them, and if she didn't, it would go back to the previous will that was giving some money to the carer. So that was the two inappropriate changes in circumstances that we wanted to overcome. Now obviously the applicant, as I said, wanted everything to go to him, and the respondent said, no, she's been telling me that everything's going to be shared between me and him. This is what she tells me whenever I go over there. I've been helping her out. She really appreciates that. She said that I should have a share in the estate. We go back to that question of, is the will that the brother was putting up one that she would make if she had testamentary capacity? And the court said, we just have no idea. We can't rely on what she's actually saying now. She's lost capacity. Yes, she's telling us that she thinks that she wants the applicant to get it all, but we can't rely on that evidence. And the court said they couldn't rely on it because she was very easily influenced. She'd essentially say whatever you wanted to hear. So when she was talking to the applicant, she obviously told him, yes, I want it all to go to you. When she was talking to Lynn, she'd say, of course, I want you to split it. I want you to have your own share. And when she was talking to the other sister, she'd say, oh, I just hate how much they're all involved in my lives and I just want to get rid of them. And so it just really depended on who she was talking to as to what exactly her wishes were. So they just weren't reliable. The second thing that was a difficulty for the court was that it was a very short relationship since the re-establishment of the relations. It was only 9 months between when they met each other again and when she was starting to put them into their will, her will rather. And they said, we just can't figure out whether you would have actually done this if you had capacity, whether that was a long enough relationship to ground them being the beneficiaries. So in the end, the court said, yes, we'll have a look at what you want, but we can't rely on it, so we're going to heavily discount it. So what can we do in that situation if we can't answer that question that we said at the beginning? And in the end, the court essentially imposed a reasonable person test, which is something that they haven't done before. So they said, what would a reasonable person in Mrs. C's circumstances have in her will? Ultimately, they did actually look at what would happen on intestacy, which would have been a third to each of these parties, and they dismissed that because the children of the brothers, the siblings over this side, didn't want to be involved at all, and they really hadn't been involved with Mrs. C for any of their lifetime, whereas these other ones had. So ultimately, they decided that 30% should go to Lynn, 30% to Susan, and 40% to the applicant, essentially because he'd been doing slightly more for Mrs. C in taking care of her. But what I find the most interesting thing about it is essentially the court just imposed its own views. Yes, it still looked at what the evidence that the parties put up as to what they thought the will should look like. Yes, they looked at what she wanted because she was physically capable of giving it the evidence. But in the end, they just said, we don't think either of those is what's going to happen. We're just going to put our own views up. But generally what's more important in our situation is to take away from this is that the court's not actually afraid of addressing these novel situations. They could recognise that there was a problem, there was an inappropriate circumstance that they had to overcome. It wasn't initially framed in the legislation for them to consider it that way, but they had to find a solution, and they did, and ultimately it probably turned out for the best. So if we've got a crazy aunt out there, or we've got a sick grandmother or whatever, and there is this change of circumstance, just because it doesn't seem to fit in that obvious sort of divorce case where you can clearly see what they would have wanted, doesn't mean that we shouldn't seek to explore this statutory will angle if it's appropriate in the circumstances. That's all I was going to say. Any questions? Yay. Thank you.